Hello, everyone, and welcome to Chasing a Murder. Today, Lori had an appearance in court for her next trial. That trial's for Brandon Boudreaux. Lori Vallow Daybell's nephew-in-law, who was married to her niece, Melanie Boudreaux Pulaski. Lori Vallow, who belonged to a zombie cult, has been convicted of killing two of her children, her husband, Charles Vallow, and her lover's wife, conspiring at least, Tammy Daybell. She's working on her third trial. Brandon Boudreaux, who was separating from Melanie Boudreaux at the time, was driving back from the gym when he noticed a Jeep. That Jeep shot at his car, missed his head by inches. Brandon narrowly escaped with his life. He called 911. And after some time, he realized that that Jeep looked familiar, and that Jeep actually belonged to Charles Vallow, who now belonged to Tylee Ryan after Charles Vallow was shot by Lori Vallow and her brother Alex Cox. So Lori is at her preliminary hearing for this third trial for Brandon Boudreaux. It looks like that she will be representing herself for a second time. Now, I don't have a lot of time to go over this, but I'll do my best. If you've been following Lori Vallow for the past 5 years, you know that she's always causing issues in the courtroom, outside the courtroom. She'll deem them zombies. In fact, everyone that died involved or surrounding her, she deemed a zombie. There's been a lot of drama when it comes to Lori Vallow. She's tried to get Rob Wood kicked off. She's had judges dismissed. And 2 attorneys recused themselves. Stay in court. She insisted, the judge over this trial, to recuse himself because she did not like the way that she was probably, that's my feeling or my opinion, she was being treated in the courtroom today. It showed on her face, blatant. She tossed her glasses, threw a fit, backtalked, overtalked the judge, was disrespectful in the courtroom, and got mad at the judge. Lori Vallow was in an argumentative mood today in court, and it showed. This is what you can expect from Lori. She actually kept her cool last court. He was really lucky. An unknown reason, Lori has lost her cool, and so that aggravation is really showing in the courtroom on Lori's face and through her actions. The state sat patient. The judge sat patient, as they have been probably lucky to not seen that side of her until recently. So I'm going to play you some of the courtroom footage where Lori lost her cool.
1 p.m. on the 29th.
Your Honor, in light of the juror misconduct or the alleged juror misconduct, I have to object to us having so much information go out about my personal information in that jury questionnaire. Do you not think that was a problem?
What personal information?
The state versus Vallow Daybell.
It's the name of the case.
Yeah, but you don't put that on anyone else's questionnaire, or one other person that's ever had that questionnaire ever put out with their name on it. They just don't do it.
I do it in every trial I've done.
You can see Lori stand quiet there. You can see that she was not expecting the judge to come back that quick and be that certain on his decision, because last trial, he was very, very cautious with Lori Vallow. Lori, as long as she felt like she felt like she was treated evenly in her eyes, which is not even, it's putting her up on a pedestal, she doesn't have a problem. Now, when we continue this video, I want you to watch closely. He kind of starts putting her in place where she should have been, because she's representing herself. And when she does that, she chooses to be an attorney and represent herself in the way the law works, meaning she doesn't get special treatment. But Lori loves special treatment, and if you don't give it to her, she's going to cause you some problems.
Then the people are just going to Google it, and then we're going to have the same exact problem we had getting a jury for that case. We're going to have the same exact problem.
Are you done? Are you just going to keep... Okay, how do we screen for if people have heard about you if we don't include your name? Do you have a response to that?
I'm just saying, you gave them the name, and they're just going to Google it.
They're instructed not to Google it, all right? And if you'll recall, when we had all the jurors come in person, one of the first questions I asked them in the afternoon was, who has looked up this case since you filled out the questionnaire? And we had 2 or 3 people raise their hand, and those people were excused. So I have to include your name to screen out for the people that know about your case. And we released about 100 jurors last time because of their answers to that. If we don't include your name, that's 100 extra jurors we have to go through in person and ask if they know you. And in fact, that increases the risk of tainting the rest of the jury pool if we have someone stand up and say, yeah, I know about her case in Idaho where blah, 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 in front of the rest of the jurors. That'll burn the whole panel. We'll have to start over. So I'm going to include your name in the questionnaire. I don't think there was any other personal information or background information about you in that questionnaire other than your name. So was there any other issues you had with the questionnaire?
No, Your Honor. No, Your Honor.
She is a very unhappy woman. You can see it on her face. And I knew exactly when she dropped them glasses, she was livid, that she was going to show her butt. But I thought she would wait until at least court was over. She ends up asking the judge to recuse herself. Something that's happened before and will happen again if ever the opportunity comes up. Now watch closely, guys. Lori's having trouble containing her temper. This is a good thing. It means that she might not be able to hold herself together this trial. The bad side is everyone else better put their seatbelts on.
So the schedule will be, we'll meet 1 p.m. to go over those answers on the 29th. On the 30th, we'll meet at 10. We'll have some point that afternoon, and then we'll plan on going Monday through Thursday, June 2nd to June 5th, then June 9th to June 13th, and if need be, June 23rd. June 23rd.
This is where Lori Vallow is about to ask this judge to recuse himself. And guys, watch closely. Is he being mean? Is he being unfair? Share it in comments below.
Your Honor,
Yes.
I have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
A lot, obviously, the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias, all right? I've over-accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that, all right? So
You denied every single one of my motions since for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not had merit? You've denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour. I have granted other motions of yours, okay?
That's the first motion that you've ever granted
Well,
in my behalf.
file motions that have a legal basis and I might grant them.
So you're saying none of my motions have had merit?
Not many, no.
And none of the motions that my first team, you denied every one of my first team's motions, you denied every one of my second team's motions, and now you denied every one of my motions until today.
I haven't denied every one of your motions.
Every single one of their motions was denied. Every single one of the second team's motions were denied, and all mine. So you didn't come into this with any bias against me in the first place?
Again, file a motion that has legal merit. Okay.
And none of my attorneys ever filed a motion with any legal merit?
They filed a motion on your behalf, the first team, to preclude media coverage, and I issued my ruling according to the law. All right. They filed a motion to have you dressed out, not in jail clothes during hearings like this. Okay. That was not based in law. I denied that motion. So I've ruled on the motions as required by law.
Without any kind of a conclusion of law in them, just denied. Does that not show a bias and a prejudice against one single person?
All right. Are you done?
Are you not going to recuse yourself?
No, I'm denying your motion. Anything else? All right. I was handed a motion to suppress all evidence pertaining to Jeep Wrangler.
I have not received that.
Did you probably got a copy of it today or not?
No.
Oh, do we need to make copies?
I just wasn't sure if you wanted to see that beforehand.
All right, go ahead and make copies for the state. I also have a motion to dismiss for non-preservation of crucial evidence.
Judge Bursky is probably going to need a shot of bourbon or something. Maybe, no, he'll probably need about 5 shots of tequila after dealing with Lori in court today. Now, guys, I've been working hours and hours and hours on my series on this case, Life Beyond the Grave. If you're interested in this case, you can check that out. What I'm going to do is play a video of one of the judges that recused herself in Lori Vallow's case. This is way earlier, but yeah, just the bullying that she and Mark Means did to people when they were working as a team. Thank you so much, guys, for watching. I love you guys, and share your comments after watching this.
And it's been stipulated that it would take place on May 7th and 8th at 9 a.m. The order to continue the preliminary hearing has not been signed yet because of this motion to disqualify. I note that there's also been a waiver of statutory speedy preliminary hearing that was filed on the 12th of March yesterday. And so, Mr. Wood, are you in agreement that I can sign the order continuing the preliminary hearing at this point?
Yes, Your Honor.
Mr. Means and Mr. Webb, do you wish to be heard on that?
James Gunson, Mr. Means here says no objection to signing the order for myself.
Mr. Webb, any?
Yeah, thank you, Judge. Right now, and I can maybe get back to you later on this, I think I need to confer with Mr. Means, but I would prefer that order not be signed at this time.
Okay. Would it be best if we took a brief recess so you two could communicate about that? It's something that I would like to resolve today just because there are several people that need to know when that hearing is going to be held, and those include people attending, subpoenas, as well as other media outlets. Would it be best if we took a brief recess so you two could communicate about that?
No, Judge, I think you should continue now. I don't think we'll be able to reach an agreement between us at this time. Just as a heads up, I think that both my firm, me and Edwina will be filing a motion to withdraw. And so I think Mr. Means I'm not sure how to answer that. I think we'll be withdrawing, and if that's the case and an order is issued, then Mr. Means' decision as the counsel to St. Vallow is controlled.
I didn't hear that last sentence. Can you repeat that last sentence, Mr. Webb?
Sure. What I'm So after the motion to withdraw is filed and I guess probably heard, then I think at that point is when I don't think a decision from my side between me and Mr. Means is going to be able to be reached, but we will be filing a motion to withdraw. And I apologize for whether overly underneath for complicating this, but I think that's what currently is a position from our side needs to be.
Mr. Wood, do you wish to respond to that?
Well, I guess that raises the issue of who is representing the defendant in this hearing. If she has two attorneys of record who seem to be having different opinions, where Mr. Webb has stated that he plans on withdrawing, and the state won't object to that. If they do make that motion, then I think Mr. Means seems to be the attorney that's speaking on behalf of the defendant. So I think the court should still go ahead and sign that order.
Mr. Means, do you wish to be heard any more on that?
I do, Your Honor. Thank you. I had a little difficulty hearing Mr. Wood there, but I think I got the gist of what he was saying. I think the determining factor here is that the client has signed the waiver for the statutory limitations on this hearing. I can clearly and unequivocally communicate to the court that it is the client's desire to waive that time limit on this hearing and have it heard on the 7th and 8th of which the stipulation was filed. I think there's also no dispute that the lead counsel in representing that to the court that it's the proper thing to do. I would agree with Mr. Wood that the ability of the court to sign the order would be the right thing to do.
All right, the court has listened carefully to the argument of both parties. The court recognizes there is a stipulation that has been filed, and under subsection A11, I think the court does have jurisdiction to rule on the issue of the continuance, and so I am going to sign the proposed order, and the preliminary hearing will be rescheduled to May 7th and 8th at 9 a.m. pursuant to the stipulation, as well as pursuant to the contested proceeding in this action. And if there has been, the time for filing has already expired. So I'm going to analyze the contested proceeding. The court reviewed Black's Law Dictionary, the court reviewed any case law, the court reviewed all of the rules and the statutes. There's no great definition for contested proceeding. In fact, there's a lot of indefinite definitions of what a contested proceeding is. The court notes that many times in criminal proceedings there are 5 or 6 criminal defendants that appear at the same time at a cattle call type situation, and a lay person looks at this and says, okay, contested proceeding means that there's disagreement. Both parties argue their own side, and then the judge makes a ruling, which is precisely what happened last time. However, the legal definition or the rule definition of contested proceeding is perhaps a little bit different. I don't know if a contested proceeding is defined by something that is filed beforehand. When the motion is filed, I don't know if it's something that indeed is just disagreed upon at a hearing that the judge makes a ruling on. But in the end, the definition of contested proceeding, I think, ultimately decides whether or not it was timely filed. There is a tendency, which is a very positive tendency, for the courts to err on the side of caution when it comes to defendants' rights. The court notes that under Rule 25, it is an absolute right for a defendant to disqualify a judge without cause. That right has to be followed pursuant to the rule, though. The problem that I have is that I don't have a definition of contested proceeding, and therefore I'm not going to rule whether or not it was, but at this time I am going to grant the motion to disqualify without cause, just because I don't have anything designating the definition of a contested proceeding, and I'm erring on the side of caution and on the side of defendants' rights to disqualify without cause. So with that will negate the need to hear further argument today on Mr. Means' motion on behalf of his client to disqualify.